For judgment, item 12. Twelve and 13.
May it please your lordship. Lordship,
These petitions have been dismissed. Return back the record, the original record, return it.
Mentioning
lordship, I beg to mention item number 10. The engaged counsel, Mr. G. Chaudhary, has gone to Mangaldoy to attend the funeral of senior advocate, Mr. Lakshmikanta Saikya. So kindly adjourn the matter for the day.
You have informed the other side.
Lordship, no, we couldn't inform.
Government, any objection? Item 10, adjournment. A prayer for adjournment of hearing of this case has been made on behalf of the writ petitioner on the ground that the arguing counsel, Mr. G. Chaudhary, is out of station. Since the prayer is not opposed by the respondent's counsel, same stands allowed. Adjournment, the hearing of this case stands adjourned for 3 weeks.
Obliged.
May it please your lordship, I beg to mention item number 7 with due consent from the petitioner. My lord, the counsel for the respondent number 2 have some personal difficulty
But
because
these
of
are
that.
top of the list matters.
Yes, your lordship, but he has the hearing, my lord.
No,
Before
no,
comes
sorry,
in-
rejected. Top of
My
the
lord,
list,
personal issue, my lord. That's why, my lord.
prayer is rejected.
Your lordship.
May I please your lordship? I prefer mention listing of the matter in the next week.
What matter?
To writ petition, land acquisition matter,
The listing for what?
listing for motion.
Motion.
It was earlier listed, again come for motion.
May I please your lordship, with the informing
Of the
other side, my lord, not be consented. 3, 4 and 5, my lord. We are supposed to produce record. That record has, as per Mr. Nath is appearing in this matter, my lord, he has informed that record has come just before 5 minutes ago, my lord. So we need some accommodation for.
The only issue is records. I have nothing to say on that. These were certain entitlements to which in the earlier round of litigation, the Advocate General has himself come and admitted that they are entitled. Based on that, those set of petitions have been allowed and payments have been given to them. We claim the similar benefit, in fact, identical benefit on the ground that since it was admitted, in their case, it has to be paid to us. So this is the only premises under which this case has to be adjudicated. I leave it to your lordship.
Finished. Now tell me the date.
Day after tomorrow, they are saying also.
The instructions and the records have come today. Can it be on Monday, Monday or Tuesday? Next
Monday, I have difficulty.
Tuesday, no?
Mr. A.
Yes.
Sharma, Learned Counsel is present for the petitioners in all these cases, 3 to 5. Mr. D.
27th
Nath,
of
Learned Senior
26th.
Government Advocate Assam,
26.
appearing for the respondent, submits that records as called for has been received only yesterday,
Today,
but only today morning,
Lordship.
and therefore some time be granted to examine the record before making submissions before this court.
On 26th.
Considering the ground on which the prayer for adjournment has been made by the Learned Government Advocate Assam, same stands allowed. However, taking note of the urgency expressed in the matter by the petitioner's counsel, registry to list these cases again
26th.
for admission hearing on 26th of September 2023 as fixed items.
Oblige your lordship.
May I please your lordship? Also, I'm very sorry that I'm mentioning a matter from yesterday's cause list. Actually, what happened, my lord, that it was an eviction matter from the district of Dibrugarh. We could, due to circumstances beyond our control, we could not reach the court on time. And there was an interim order and the interim order was not extended. And my lord, this is an eviction matter where, my lord, the people have Pradhan Mantri Awas Yojana houses over the land.
Nothing can be done.
My lord, they will suffer because of the council's mistake, my lord.
Nothing can be done. Without the record, no order can be passed. You have to file an IA.
We have filed today, my lord. If that can be called it today, my lord,
Today
at
not
2 p.m.,
possible.
my lords.
Not possible. Tomorrow.
Tomorrow, my lords.
And then court has observed that there is no ground to extend the stay order.
No, my lord. Actually, if I may submit for 2 minutes, my lord, there is an order by your lordship in a matter Salakuddin.
You submit a mention memo for tomorrow. If
Tomorrow.
there is an IA filed.
IFI. Yes, madam. Tomorrow we'll file there. Much obliged, my lord.
Your Lordship, I beg to mention for listing of a writ petition, Lordship. Lordship, for admission, Lordship. Can it be? tomorrow?
Yes, it can be after vacation. After
Lordship,
Puja vacation, before
Lordship,
that, no.
may I pray, Lordship? Lordship, last it was listed on 9/8, which on that day it was fixed for after 4 weeks, but till now it has not been.
What is the
listed.
matter about?
Lordship, the petitioner has applied for water supply for in JMC, but earlier it was allowed, but again, due to some miscommunication, they have rejected the prayer. Lordship, we have filed this. Now petitioner is suffering due to they don't have water, Lordship.
We do it on the week commencing from 3rd of October. Any day on 3rd of October.
Third of-
From 3rd of October, yes.
Online such.
Daily list for motion item 1.
Please, Lordship. My lord, here, my lord, in the case we have filed our reply, my lord, but the reply affidavit, my lord, reflects something else, my lord, because it says, my lord, it is a revenue village, my lord. And moreover, my lord, we got and downloaded yesterday, my lord, from the internet, my lord. It
Mr.
reveals-
Bobia, I have not understood anything what you are saying. You want adjournment in this?
No,
case?
no, no,
Then what are you saying?
my lord, they filed their affidavit.
What affidavit? What is this writ
Affidavit
petition
filed
about?
by, it is eviction matter, my lord.
Hmm,
Affidavit filed by the circle officer as per the direction of the court, my lord.
hmm.
They said, my lord, just for a namesake, they went there, my lord. They have not adopted any scientific method or any way, my lord. They simply said it is a forest land. But from the RTI, my lord, reply in the earlier round of litigation, it seems, my lord, it is a revenue village. Apart from that, my lord, yesterday we
You
got,
argue your case.
yes, my lord.
Argue your case.
Before that, my lord, I like to show a lordship the copy, my lord. Lordship will see for a moment, my lord, before starting serial number 146. It is very much available in the website, man.
No, website means whose website is this?
It is, my lord, in the Google, my lord, we got it. It is a Google shows,
Whose Google you will get it, but Google's document. Then we'll not rely upon it.
no, lordship for a moment, because other villages is also
So
there.
you argue your case,
My
Mr.
lord,
You are
my-
going,
My
as
lord,
if the order will be
my-
passed right now.
my lord, my lord,
Nothing unless you convince no order.
my lord.
Hmm.
Initially, my lord, we have approached to the owner.
Who are the petitioners?
There are the resident of that particular area, my lord, NK Daranga.
Hmm. Residents means they are occupying what? Sarkari land.
According to them is the Sarkari land.
According to you,
According to me is also Sarkari land, because the documents supplied upon me, it seems, my lord, Sarkari land.
right?
Right from way back 60 to 70, my lord, they are residing there, my lord.
Hmm. So they are occupying Sarkari land.
Sarkari land.
The government now wants to evict them from
My
the
lord,
Sarkari.
Forest Department.
Yes.
Forest Department has come, my lord. They are saying, my lord, it is a forest. So you go. And they said, my lord, very ridiculous manner, my lord, they have issued a impugn eviction notice, my lord. That your lordship will see page 69. And vernacular is the next page, my lord. For
Who is for the district administration? Government?
From BTD, my lord,
Hmm.
also representing respondent number 7, my lord, the circle officer.
According to you, this is forest land.
Yes, my lord, this issue has already been addressed in the earlier round of litigation, my lord. In the affidavit is clearly written in our affidavit in
All right,
our.
let him finish.
It is a forest land, my lord.
lordship will see page
It's
69.
categorically
69 was the notice,
stated
my lord.
in the affidavit.
Page 69 is the notice, my lord. Initially, they have issued to us, my lord.
Hmm.
Vernacular is page 70, my lord.
How many petitioners?
Here, my lord, 80 88 petitions.
There are two writ petitions, is it?
No, my lord.
All right. Eighty-eight petitioners.
No. Notice was issued to us, my lord. Accordingly, we challenge it, my lord. Then, my lord, Honorable High Court passed an order, my lord, asking us, the asking authority, operative part at page 85 and 86, my lord. Lordship kindly skip other part, my lord, para 8 at page 85. Mr. B. Chaudhary, Land Standing Council further expresses the appreciation if the petitioner remains present. There may be law and order situation. Mr. J. I. Borvia, Land Council for the petitioner submits that petitioner number 1, Mujibur Rahman, shall represent all the petitioner be present, and Mr. B. Chaudhary, Land Standing Council, so and so submits that on instruction that the field verification process would be carried out on 19/8/23 at about 12:30 p.m. Taking into account of the above, this court is of the opinion that it would be for the interest of justice to dispose of both the writ petition with a direction to the Deputy Commissioner Baksa to deputy Circle Officer Tamalpur to carry out the field verification by taking into account the revenue records maintained as to the land records petitioner are in composition falls in the forest land or government lands. The divisional forest officer, the Baksa Demarcation, shall also be present at the field verification. So and so number Mujibur Rahman shall also personally be present at 12:30 at the time of the field verification. The circle officer Tamalpur shall thereupon carry out the field verification, and on the basis of the said verification, respondent authorities shall take steps as permissible under law. It is made clear that till such verification is concluded, the date of fixed, the status quo order passed by the court shall earlier remain in force. Now, my lord, the honorable court asked them, my lord, to go for a field verification. They went there simply, my lord, simply going and taking phone number of photographs only of the petitioner, my lord. So that, my lord, they have already done that job. But I have annexed a document, my lord, that it is very much existing at page 74, my. There is a pillar mark.
Mr. Borvia, the departmental officials say it is forest land. You say it is not forest land.
No, my lord, department, my lord, only, my lord, the circle officer saying a forest land.
No, my lord.
Same circle officer.
It is joint verification, my lord.
Same circle officer, my lord, in the round of RTI, my lord, in respect of another PL. He said, my lord, it is a revenue village, my. For which, my lord, lordship kindly draw attention affidavit reply, which I have filed on 7/9.
See,
my
the point is as simple. If you can prove that it is not forest land,
lord,
then it's another thing.
my lord.
Otherwise, there is already an order of the court to verify and
My
take
lord,
action.
verification, there is a process is there, my lord.
What is the process?
Lordship, kindly, I have made a statement, my lord. Lordship, before that, my lord, how they have to find out, my lord. Lordship will see they have scientific method is there, my. They have not done so. That method is known as, my lord. This is for example, my lord. In case of other Dibru Shaikia, my lord, there will be clear picture, my lord. That has not been done, my lord. They simply took out the photograph from Google and they said, my lord, this is the way. And that process is known as, my lord, geodetic coordinate system, my lord. If geodetic coordinate system is.
Mr. Borvia,
Lordship.
we can consider giving your client some time to vacate the forest land. Think about it.
My lord, one
The writ court cannot go into dispute
Lordship,
whether it is forest land, we'll go by that.
Lordship, for a moment, Lordship will see, my lord, in respect of another PIL, my lord, filed by the other person, my lord, regarding tribal land and non-tribal, my lord, to be evicted. Then, my lord, they have filed, went to the field verification. There they said, my lord, it is a revenue village, tribal land. They are making their own contradictory, my lord. That's why, my lord, geodetic coordination has to be there, my lord. For Lordship, kindly have a look, my lord, affidavit of the reply which I have filed at page, Lordship will see 104. By another person, my lord. Lordship will see NK Agarekata village falls under tribal band. And Lordship will kindly turn to next page. 105. Number 1, my lord, NK Daranga falls under my lord revenue village. NC Daranga, NC, NK all the same, my lord. Number 1, my lord.
Now, how do you say from 105 that it is?
NK Daranga, my lord, it is name of the village is there, my lord.
Hmm.
NK Daranga, revenue, my lord, Kumarikata, then my lord, Tamurpur block. It is there, my lord.
So your clients are occupying NK Daranga.
NK Daranga, only NK Daranga. Initially, they issued a notice saying that we are using name Mainali. Mainali is totally different land, my lord. And particular,
No, now, these arguments would hold water if there is a conflict between the forest authorities and the revenue authorities.
my lord,
But in any case, this is not your private land.
my lord, not private.
So assuming that it is not
Government.
forest land, it's a
Right.
revenue village.
Then, my lord, section land revenue, my lord, notice will come, my lord. In that case, my lord, rule 18, my lord, I have quoted, my lord,
Hmm.
that will come into play, my lord. Notice and everything will come, my lord. Rule 18 of chapter 1, my lord, the deputy commissioner has to issue notice, then only will come, my lord. Then I'll give my,
Then what will you say? It is not your land.
it is not my
Sarkari
lord.
land.
My lord, it is a Sarkari land, my lord.
So notice will be only giving time to vacate. That's all.
My lord, we are landless people, alternate remedy, my lord, I do not have, my lord, landless people, my
So
lord.
therefore, what is the remedy? There are, is there any principle, policy, guideline? Landless people cannot occupy Sarkari land.
My lord, my representation is there pending, my lord. They
For
have
what?
taken For giving us the settlement, my lord, if it is a government. That representation has not been.
Mr. Borvaya, you have to elevate your case a little more, otherwise difficult. Because there are large number of Sarkari land which have been occupied.
My lord.
We will have to go by legal
My lord,
principles.
had it been, my lord, for any other purpose of the public interest, then otherwise, my lord, this is a big jungle, my lord, lordship may be ever, my lord, in between the border of Bhutan and India, my lord. To that time, my lord, I do not have the document, my lord, to control our position. Government of India allowed us to remain there.
Government of India allowed.
My lord, that time, my lord, for contracting, my lord, for protecting the border. That is the main issue. But I do not have the document of those days.
Hmm.
That is the basically, my lord, international border, my lord.
You want to evict them, but you have to give them alternative
My lord,
land.
kindly appreciate, this is second round of litigation. First round, my lord, there was a clear finding of this honorable court that these are questions of fact, this court will not entertain. That's why, my lord, circle officer was directed to cause a field survey along with the petitioner's presence, my lord. It was done. Now they are basically making a correction of prayer, my lord, in the first petition. There was nothing.
No, but you can't just throw them away.
Yes, there is a land policy, my lord, they can apply every eviction, my lord, wherein there are
Till
challenges
such time their land applications are considered,
that doesn't.
their livelihood will be taken care by the institution. That undertaking you have to give us. You evict them. But you cannot throw them away. This is a welfare state.
If this is a welfare state, my lord, this same welfare state also enacted, my lord, Forest Conservation Act, Forest Dwellers Rights
You
Act, my lord.
evict them from forest, but
Yes.
you are also the administration. You are
Yes,
representing.
we'll
the-
provide them the basic facilities, my lord, till they are rehabilitated. That is everywhere we have done, my lord. There are orders passed by this honorable court that they cannot be evicted without providing them basic amenities. And, my lord, they were allowed to approach the authorities under for allotment of land under land policy of the government, my lord.
We have,
These are the common orders passed by even by the division bench, my lord.
we have done already, my lord.
Now, making a representation before the DC will not suffice, my lord. There are other requirements under the policy that they have to follow. They have to establish that they are landless, they are
Mr. Borbaya, we have to balance equities. You
Loss.
cannot remain in occupation of
Loss.
government land.
I need, my lord, alternative method of rehabilitation somewhere, my lord, because I'm landless people, my lord. I have nowhere to go. And very poor
No, no,
person.
how can you be landless? Where you must have had, your ancestor must have had land somewhere?
No, my lord.
Nowhere.
Nowhere, my lord. I had a land before somewhere, my lord, I asked them, some of them. my
I
lord.
had no knowledge,
They
they
said,
have,
my lord,
there are so many.
They said, my lord, river, my lord, washed away their land. So accordingly, they came there and settled there.
River washed away their land.
Hmm.
Where is, which part? Show me the, give me
Which
the
part, my
document.
lord, it cannot be, my lord, for the instruction I have taken from him, my lord. And they are saying, my lord, their grandfather came in 1970, my lord.
Came from where?
From Assam only, man. They are came for livelihood. They worked there as a
So many of them, 88.
88, my lord. A particular one village, my lord, and Kedaranga. Lordship, kindly have a look the map, my lord. Others are has been not been targeted. Only, my lord, Lordship will see the book. I have annexed map at
Map
page
pa-
73. 73, Lordship, kindly have a look.
Hmm.
Others villages are there. They are not targeting to that. Lordship will see that this is the map, my lord.
No, Mr. Borbia, the point is, if you are in occupation of reserve forest land or say government land,
Right.
Sarkari land, then can you assert a right to continue
No,
in
ma'am.
occupation? Then
I do not.
your best case is that it is not a forest land,
My lord,
but then also it is a Sarkari land.
my lord, Sarkari
So
land, my
if
lord.
they want to evict you from a Sarkari land, are they required to give explanation why they want to evict?
No, my lord,
Then
it is not that.
What is the law? Tell me that.
Law, my lord?
If
If
there
it
is a
is the
law
Sar-
in your favor, I'll
If
pass
it
an order.
is, Lordship will see, if it is their government land, my lord, they need to have issued under rule 18(1), my lord, that I have reproduced at page 17, my lord.
But there are judgments that encroachers need not be served with prior notice.
My lord, to that effect, my lord, some other cases I have seen in, my lord, in the judgment also, my lord, they provided alternate remedy,
Alternate,
my lord, rehabilitation. Somewhere, my lord. It is not, my lord, particular area I want, my lord. I need somewhere, anywhere, my lord. I got my small children also. I am at the age, some of them are not age about his grandfather died.
no, Mr. Goswami, one thing you can be sure of. Even if we permit the eviction, you have to take care of them.
Definitely.
How will you do it? Give us a plan. How will you do it?
My lord,
You
we-
cannot, because these are human issues. These are
True, my
people
lord.
with
We
their family.
will consider
children.
their applications for settlement of land, my lord.
Hmm.
Depending upon the merit, they will either get it or they may not get it because
Until
state is
such
not
time-
with, state is also not with so much of land that says state can allot everybody a plot of land, my lord.
Until such time.
Until such time, my lord, we'll rehabilitate them somewhere, we'll, my lord, place them and provide them with the basic amenities. That is what we have done every year, my lord. But law is absolutely clear, my lord. They cannot have a claim over forest land, my lord.
My lord, my
And-
humble submission, my lord, let them give our alternate somewhere, my lord. We are ready to.
Settlement.
Not, my lord, at least for,
They will
rehabilitate.
provide you food, water, shelter,
Yes, ma'am.
basic amenities. And we'll give you time, say 3 months time.
And my lord, we'll also
let them
consider,
consider our whatever representation or
Yes.
necessary, will file fresh.
let them file fresh petitions for my lord
File
settlement under
fresh
land policies. We'll consider, my lord.
Only, my lord, my
Hmm.
submission is that, my lord, relating to,
You want an order to issue patta also?
no, not that, no,
What
no,
else you
I
need?
don't want, my lord.
Huh?
What I wanted
Why
to,
don't you want?
I wanted to convince your
There
lords.
is, there is no bar in wanting anything from the
No, my
court.
lord, I am
You
told
can
I
ask for
don't want.
anything.
I'm told I don't want.
No,
What-
why don't you try that?
My lord, my,
Ask for a mandamus to issue patta in favor.
my simple submission was that, my lord, so
Hmm.
far other case, my lord, Dibru Sokia case I have done, my lord, conducted, they come with the coordination system, my lord. They are my
No, no,
lord.
Mr. Borbia, the other case we'll see in other case. What happened in other case, other facts.
Only, my lord,
Here,
rehabilitation
In
be,
the facts of
be
this
provided.
case, what is the right you have? You tell the court, you are not being able to say.
right in
You
the
are in
sense,
any
my lord,
case occupying government.
my lord,
land.
I am occupying the government land
So,
right from my
we
grandfather's
don't
time.
see any reason why the government must give a show cause reply to the court,
And
why
my
they
lord-
want their own
And
land.
very interestingly, my lord, government themselves provided, my lord, Indira Awas Yojana, electricity, pump, road, everything they provided. Now they said, my lord.
Because the government has changed,
Last it,
what to do? We can't comment on these things.
last.
We'll go by what is the legal.
Lordship,
principle.
my lordships, my lord, somewhere rehabilitation, somewhere, my lord. Till then, my lord, if they consider, my lord, is well.
It will be the responsibility of the deputy commissioner of the district. And other authorities will cooperate because this is an element where the court is always
Yes, in fact, if
concerned.
my lord allows me some time, my lord, I will place those orders of this honorable court when, while my lord, we evicted from Lamding,
Hmm.
this sort of arrangements were made and it was endorsed by this honorable court.
Then we'll have it day after tomorrow. We'll
My-
give all the orders.
My-
You also be on notice.
Yes, yes,
The order I propose to pass is 3 months time from day after tomorrow.
yes, my lord.
Within that time, you will vacate the land yourself, removing your belongings. They will,
To go, my
huh?
lord. Question, my lord, where shall I?
From
go?
wherever they have come.
Only street I have to.
In Lamding, my lord, we have seen, they have encroached Lamding Reserve Forest. Everybody was holding a voter identity card from Morigao district, my lord. Though the right itself means, my lord, they had land in Morigao.
No, my
Despite
lord,
that,
my
they have
voter
went
list
into
is there,
Lamding
my
Reserve
lord. I have
Forest.
an ex-voter list also. In the instant.
So then if you have an order, you
Yes,
give
I'll
it and
produce by day after.
circulate it to him.
I will give him to,
This is
give
a
it to
court
him also.
process. Will,
Day after,
see, the
Not
court
that,
is only concerned with the legal
Right.
principles.
my lord.
Otherwise, we are not concerned who is evicted, who has voter list. These are not the matters of this case. On what principle do you say that the state cannot evict from Sarkari land? That's the reason.
Yes.
But that doesn't mean we'll be oblivious about the.
Their basic rights, my lord.
Because Article 21 is
True, ma'am.
applicable to all human beings,
All. Even if,
including non-citizens.
including non.
You have to discharge your duty under 21. So give us a plan.
Day after tomorrow, my
After
lord.
tomorrow, you give a plan.
Wednesday,
How?
Friday.
Huh?
Friday, my lord, not there.
Friday.
My-
Friday is a better day.
No, my lord, Wednesday I got some other motion matter before your lordship also.
Wednesday, that's why we're putting it on Thursday. Not okay.
All right,
Friday.
all right. No problem.
Friday will be difficult. Then it
Last,
goes to
last,
Monday.
last. Any comment?
All right, heard Mr. J. Bodvi, learned counsel appearing for the rate petitioner, also heard Mr. P. N. Goswami, learned additional AG Assam, along appearing for the official respondents, along with Mr. S. Rava, learned SC BTC, and Mr. D. Gogoi, learned SC Forest Department Assam. First up, the read petitioners herein, numbering about 88 in total, have approached this court by filing the present writ petition, apprehending their eviction from the land under their occupation, full stop. According to the respondents, the petitioners are in occupation of reserve forest land, and therefore
Doronga Reserve Forest. my lord.
Doronga Reserve Forest land situated in Buxa
Buxa
district. However, the read petitioners have disputed the said assertion by contending that the land falls within NC
Daranga Revenue Bill.
NC Daranga Revenue Village. Full stop. Taking note of the controversy, the learned single judge had passed order dated
Last connection.
16/8/2023.
16/8/2023. In the earlier round of litigation by and between the parties in WPC number 4395 of 2023, directing a field verification to be carried out by the departmental authorities in presence of the petitioner number 1, who was to represent the other petitioners. Accordingly, the field verification has been carried out and a report has been submitted annexed to the counter affidavit filed by the respondent number 7, so as to reaffirm that the land in question falls within the Daranga Reserve Forest. First up, the counsel for the petitioner has, however, assailed the said report, inter alia contending that the authorities have not followed proper procedure of field verification by using the latest technology in the form of
In the form of my lord,
GPS.
no. Geodic, my lord, page 26 BC, my lord. Geodic coordinate system,
geodic.
geodic. In my prayer, it is there, my lord, page 26.
No, you can't get so technical about these things. Geodic
Geodic coordinate system.
coordinate system. Be that as it may, the petitioners are, however, not denying the fact that they are in occupation of Sarkarian land. First up, if that be so, this court is of the prima facie opinion that the writ petitioners cannot resist any move by the departmental authorities to evict them from the land, even assuming that the same is not situated in a reserve forest. Full stop. Therefore, the only question that would arise in the present writ petition is as to whether some time can be granted to the petitioners to vacate the land themselves, and if so, what alternative arrangement would be made by the respondents for rehabilitation of the petitioners by affording them the basic amenities, including food, water, and shelter, until such time their requests for allotment of land is considered by the authorities in accordance with law. Mr. Goswami, learned additional AG seeks time till Thursday, give the date, to come up with a concrete proposal in that regard by drawing support from earlier orders passed by this court in similar matters. Prayer is allowed. Let this petition be listed again day after tomorrow, that is
21/9.
21/9/2029 as a fixed item. The learned additional AG to circulate copies of decisions of the court and proposal, if any, with the petitioners council by tomorrow. Let him circulate, you come up.
Then means whatever I'll get, I'll supply.
Yes.
Because in
But
other
you know which way it is heading,
my lord.
so you better come prepared on that. Geotechnical factor, we are not getting
Till
into.
then, my lord, they shall not take any action. Well,
There
that
is no
are
question.
Obviously, they are not-
Obliged.
obliged.
Item three.
Yeah, please. Kindly pass over the matter for time being, my lord. Armazones are supposed to.
Thursday motion, no passover. Where is the synopsis?
Even.
Where is the letter dated 4/9/2023?
1923. Page 41, my lord.
Page
41. And 42.
Where is the name of your client in that list?
Serial number 51, my lord.
Yes, what do you have to say? They are occupying immovable property. Where is the power to issue letter like this?
Lordship, they were granted license, Lordship, as per the agreement dated 27.
No, miss, you please tell me one thing. They are occupying immovable property. Let's take that they are tenant at sufferance, or they have They have held over the land after expiry of the license.
Yes, Lordship.
Then also you cannot just go and bid them and out of the land.
As per the agreement, Lordship.
What is the procedure under law you have adopted? Which process?
Lordship, as per the agreement, clause 20, Lordship, 32.
So I am asking you, you have
Lordship.
not understood. Supposing you have a tenant,
Lordship,
your agreement is for 1 year.
1 year.
After the expiry of 1 year, can you ask your tenant that go out or I'll throw you out? Can you do that?
Lordship, during the agreement period, they can issue notice.
All right, you have not understood. So we'll have to go into it. Heard, Mr.
H. A. Talukdar.
H. A. Talukdar, learned counsel for the petitioner, assailing the,
Lordship, as per the agreement, they can do, Lordship.
which is the law I'm saying? Agreement does not make law.
Lordship.
Under which provision of law this letter has been issued? I'm asking you that.
Lordship,
Which provision of law?
Lordship, as per the agreement, they have is a
The agreement is the law.
not law, Lordship, but since it was agreed by the parties that after expiry of the license, they can.
So that is what I'm saying.
position,
Supposing
Lordship.
somebody A occupies B's premises
Lordship.
for a period of 2 years. After the agreement expires, A asks B to vacate, he does not. Then what is the remedy for B, for A? Either he has to go to the court and obtain a decree, or there has to be some statutory provision which has to be pressed into service.
Lordship.
Agreement cannot be the ground to evict someone from land.
It is only for temporary occupation. It is clear.
All right, if you don't want to understand,
Lordship,
despite you,
Lordship, I
all right,
understand.
then it'll take time.
Lordship.
So and so for the petitioner assailing the letter dated 4/9/2023, by means of which the writ petitioner, along with 52 other occupants of railway land, have been asked to vacate the land within 15 days. The instant writ petition has been filed. According to the writ petitioner, he was a licensee in respect of the said plot of land and was occupying the same on the basis of a license agreement, which was extended up to 31/3/2023. Full stop. After the expiry of the agreement, the petitioner has submitted a request for renewal of the agreement. Full stop. Notwithstanding the same, the impugned letter has been issued. Mr. Your name, please?
H. A. Talukdar.
Huh?
H. A. Talukdar.
Mr. H. A. Talukdar, learned counsel for the petitioner, submits that his client is earning his livelihood by running a pharmacy established over the plot of land, and therefore, if he is evicted from the land without following the due process of law, the same would result into serious prejudice to the rights and interests of the petitioners. First up, on a pointed query made by this court, Ms. R. Devi, learned CGC, appearing for the respondents, could not furnish any answer as to under what provision of law the respondents had initiated the action in the form of letter dated 4/9/2023. Full stop. The question that would arise in this writ petition is as to whether, even if it is assumed that the license agreement has expired, can the respondents evict the licenses from the land merely by issuing a letter without there being any statutory backing for doing so? Full stop. Since the learned CGC has prayed for some time to obtain instruction and place the same on record so as to answer the court's query, I am inclined to issue notice in the matter. NOM 4 weeks, make it 6 weeks. Since Ms. R. Devi, learned CGC has appeared and accepted notice for all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned departmental counsel, requisite in numbers, so as to enable her to obtain instruction. Register to list this case again on 30th of October 2023 for admission. Status quo as regards the land under occupation of the petitioner shall be maintained till the returnable date.
My lord, supplementary item 14, similar matter, my lord. Favor similar order.
You are appearing?
Lordship.
So there are multiple petitioners
Yes,
here.
Lordship, 16 petitioners.
16.
So same thing petitioners and
But, one thing, Lordship, they had also stated that as per clause, they
see,
should,
I'll tell you. You find out. If you can find out till
generally-
the next date, it's very good. But today you will definitely not be able to answer. The agreement has expired.
Lordship,
You are not an extraterrestrial entity. You are just another entity. Supposing you put a tenant in your house
Lordship.
for a year on the basis of an agreement. He is also your licensee. After the expiry of agreement, can you go with some strong people and throw him out of the land? Of the
Here,
premises? You
but-
cannot.
Lordship.
You can either do it by a decree of the civil court or by initiating an action which is statutorily permitted.
Generally, a state officer issued a,
Ah, there
they
you are.
can challenge it before the district judge,
Correct.
Lordship.
You have
Then
not done it.
They,
She could not answer it. So I already fixed the matter on 30th.
31st of March, they are unauthorized occupants.
Maybe, but you cannot touch them unless you go to the
Yes,
civil
that
court
should be,
or you initiate a
state
proceeding
of-
on it.
State officer.
So you have not done it. How can you throw them out? I asked your colleague, she could not answer. You have come near to it, but you have to either file your reply or you have to initiate a fresh action. In either event, the writ petitions will be allowed.
That may be permitted, Lordship,
Hmm.
that due process of law, they may.
No, you first file your reply. I have already issued notice. 30th of October, you file reply. If you concede, we'll set aside and then you initiate action under the law.
Lordship.
But certainly you cannot write a letter and drive people away from immovable property where they were licensees earlier. This is not permissible. You can't do that. So this letter in any case will go. Okay, it could have gone today. I given her a scope 3 times. I asked her, she couldn't answer. If she would have considered, I would have set it aside. So and so, 16 petitioners. List again 30th status quo. On
Hello,
on
guys.
30th, you put your stand. If you concede, we'll allow the writ petition. That will give you the entire world free. And then by that time, they will have to figure out what they have to do. Instead of writing this letter, if you would have issued notice under the
Public premises.
Private Premises Act, the matter would have been completely different. So you are the one who is 30th of August, 30, October. Is it a holiday?
Only the Lordship.
Achha, then we'll have it, yes, there has been some change.
Fifth,
So then we'll have it on
Fifth.
16th of October, 16th of October.
16, I have difficulty, Lordship.
Then
16
it
last
will-
next week,
Then it will go to 6th November,
Lordship. In that
6th
case,
November.
Lordship. We have to file also,
Hmm.
Lordship.
6th November, the other matter also 6th November.
Lordship.
Till 6th November. Beyond that, get ready. Yes.
Item 15.
May it please your lordship.
What is the matter, Mr.
Well, the petitioners are recorded pattadars in respect of the land in question.
Hmm.
After the pattas were issued, certain complaints were made by the private respondents claiming that they are the successors of my vendors, and therefore their names should be initiated, mutated, and the patta should be cancelled. At that stage, I came before this honorable court with the question whether the revenue authority can decide the question, go into the question of title. Page 78, your lordships will find the order passed by this honorable court requiring the revenue authority to first decide whether he has jurisdiction to decide the case, decide the issue or not. Page 78, your lordship will kindly see. Page 78, 4th paragraph. In view of the projection made in this writ petition, which is supported by entry made in Chitha, that a separate DAG was created pursuant to order passed in partition case number so-and-so. While determining the matter in case number so-and-so, the circle officer, while determining the matter in case number so-and-so, shall first determine whether he has the jurisdiction to cancel the order of mutation under the provisions of Assam Land Revenue Regulation, and thereafter he will fix another date for passing of the final order. Now the final order has come at page 82 without deciding the question as was directed by the honorable court. And eventually, my lord, in respect of the private respondents, he has allowed the mutation in place of my vendor, along with my vendor. That is the case.
If you file an appeal under the land revenue regulation,
Now, we are.
this matter you wanted to move unlisted yesterday.
Yesterday, because my lord, the imminent position is that the order has been passed and they are going to correct the revenue records. Now it will give rise to multiplicity of proceeding. Our basic question is that since the issue involves the question of title, because we purchased the lands through two sale deeds. And by virtue of those two sale deeds, the mutation was done and the chitta was prepared. Now pattas were also issued. Now whether.
So this has
including
to
the
go to
question
the
of-
civil court.
Yes, so they had to go to civil court. So therefore, in the writ petition which is pending now, the previous order that I had shown to your lordship, this honorable court directed the first you decide that in these peculiar facts of the case, whether you can decide the issue yourself or not. The circle officer has not gone into that question and passed the impugned order. That writ petition is still pending, Lord. 362, that is 3621 and yes, 3621 of 2023. And page 82, the final order has been passed. There is no whisper about my projection of the case. The fact that I purchased the land through sale deeds, nothing.
Which is the order of the circle officer?
Page 82. He has decided the application merely on the basis of a draft chitta. The complainant and the opposite party are present. Notice was duly served. Latmandal has submitted his inquiry report on the basis of the report of Latmandal, hearing of the complainant and opposite party and documents submitted by the opposite party. The case is fixed today for final hearing. One late Kushal Poddar, the father of the applicants, so and so and so and so, was in possession of the land covered by. Now, this possession has been decided. This possession has been reflected in the draft chitta. Now, the land we purchased are from the erstwhile riots of the original Pattadar. And in that Rayati Khatiyan, the name of this person never appears. On late or so and so. Subsequently, Javed Ali mutated his name alone through inheritance over the entire share of late Kushal Poddar, and the applicants are remaining legal heirs of the late Kushal Poddar, applied for mutation of their names against the dag and patta of the land in which the name of Javed Ali is inserted by mutation and partition. On the basis of the application of the applicant, the case was registered and both the parties were asked to appear in the court for hearing. Applicant stated that Kushal Sheikh was in possession over the land covered by patta number so and so, dag number so and so, situated at Revenue Village so and so, and submitted the copy of draft chitta. As per the said draft chitta, the possession of late Kushal Sheikh, son of so and so, is proved. Considering all
Is draft chitta admissible? Draft chitta, is it admissible as evidence?
That I have.
Is it admissible?
No.
Why not?
Because, my lord, it is only in the draft chitta is prepared only on the basis of possession of the land.
No, there is a judgment of this court.
Practical possession, actual possession. But here is a case, my lord. If your lordship will kindly see the draft chitta, which is at page 85. 86 is the original one, 85 is the printed, typed copy in English. If your lordship will kindly see, here the name of, at page 85, your lordship may see, the name of Dakhaldar has been indicated. Now, this gentleman whose name has been shown as Kushal Sheikh, he expired long time back. Even his sons and one of his son is also not alive.
What is the meaning of, if there is no objection, the concerned Latmandal will correct and record the place, record and place the same person. If there is no objection.
Page 83.
Yes.
Now this is again very confusing because he has already decided the issue. Now what the Latmandal is with no authority to decide the question. He has already decided the question whose name has to be entered into the records.
No, but there is a title, your title is clouded. You have purchased the land.
Yes,
Your title is clouded, you have to go to the civil court.
My lord, actually, it is my humble submission is that it is the other way around. They ought to have gone to civil court questioning my title. Instead, they initiated a proceeding.
They did not go.
They did not go, and therefore, this honorable court directed the
So
revenue.
now your title is clouded.
No, what I am on, my lord, this honorable court directed in the page 78 order that the revenue authority will first decide whether he has jurisdiction
No,
to
that
decide.
is all right. That what is there to, obviously decide. These are officials and executives. So he has decided that he has jurisdiction. He has not said
No,
it
he
in
has
so-
not, he has not even.
No, they don't write orders like judicial officer. That point will not help you much, Mr. Datta, don't. Because they will decide and these are not, you see, we are not dealing with high courts and Supreme Courts. Supreme Court saying the high court will first go into the question of jurisdiction and all. These directions don't carry much meaning with the revenue circle officer. He is not a trained judicial officer.
But even at.
So it will be treated that if he has allowed the petition, he has effectively held
No,
that he has.
even in that order, I am on the merit of the order.
Hmm.
There is no discussion as to the sale deeds that I produced before him. There, the pattas that I produced before him. There is no discussion at all. If your lordship will kindly see my written statement that I submitted before him.
All right, we'll send you to the civil court, but on the next date. Let there be some notice, but you will have to go to civil court with this matter. There is no.
Well, my submission is that this order, the authority does not have jurisdiction.
And
at
why
all.
haven't you preferred an appeal? It's an appealable order.
Provision of appeal is also
No,
2 months.
I am challenging the question of jurisdiction, my lord.
It cannot be done in an appeal.
But at the same time, my lord, if I file an appeal indirectly, my lord, I am assuming that he has jurisdiction to do it.
Mr. Doctor, please argue on that law. This is a new law. Filing an appeal means accepting the order of the.
No, I am challenging the jurisdiction in the sense that under the land revenue regulation, and it has been decided by this court that where the question of title gets involved, the revenue authority should relegate the matter to the
That's not
civil
the
court.
point. Point is, this order is appealable. Why haven't you preferred an appeal?
Appeal could have been preferred, my lord, but still it is not a bar for your lordship to examine the question whether he can do so. And more so when this honorable court had at one point of time, it has indicated the situation that he has to decide the question first, and thereafter he has to. The order is very specific that first he will decide that he has jurisdiction, and thereafter on the next day he will pass the final order. If your lordship will kindly see page 78 once again, the order is very clear. Paragraph 4, in view of the projections so made, the circle officer, revenue circle, while determining the matter in case number so shall first determine whether he has the jurisdiction to cancel the order of mutation under the provision of Assam Land Revenue Regulation, and thereafter he will fix another date for passing final order. This is very specific, and this is what I placed before the revenue authority.
Yes. What do you have to say?
My lord, it related to filing of appeal, my lord. Filing of appeal for determination of their rights, my lord.
All right, I heard Mr. S. Dr. Learned Senior Counsel,
Otherwise,
Ms.
dispute is
Asra Learned
later.
Counsel appearing for the writ petitioner, assailing the order dated 1/9/2023, passed by the Gauripur Revenue, passed by the Circle Officer, Gauripur Revenue Circle, that is the respondent number 3 herein, allowing the application filed by the respondent numbers 4 and 5 for correction of revenue records. The instant writ petition has been filed. Mr. Datta has argued that the impugn order is not only perverse, but also in clear violation of the directions contained in the order dated 23/6/2023, passed by the learned single judge in WPC number 3621 of 2023, wherein a direction was issued to the respondent number 3 to first decide on the question of jurisdiction and then fix another date for passing the final order. Full stop. On such ground, the learned counsel for the petitioner has prayed for setting aside the impugn order dated 1/9/2023. Full stop. Ms. M. Burman, learned government advocate Assam, submits that the impugn order is appealable and therefore the writ petition is not maintainable on the ground of availability of alternative remedy. Full stop. Be that as it may, after going through the materials available on record, this court is of the opinion that the matter calls for deeper examination. Full stop. As such, NOM 6 weeks since Ms. G. Hazarika, learned SC Revenue, has appeared and accepted notice for respondent number 1, and Ms. M. Burman, learned G. Assam, for respondent numbers 2 and 3. Serving to notice upon the respondent numbers 1 to 3 is deemed to be complete in this case. Extra copies of the petition be furnished to the learned department council, requisite in numbers, so as to enable them to obtain instruction. Stop petitioner to take steps for service of notice upon responding number. Petitioners, who will take steps for service of notice upon respond numbers 4 and 5 by registered post with AD within 3 days from today. Full stop. Hard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that operation of the impugned order dated 1/9/2023 shall remain suspended until further orders. The question of maintainability of the writ petition is kept open and shall be gone into at the stage of admission hearing.
For admission, item 6.
May I please the lordship?
Now, before my learned friend begin, my lord, participant in this case, my lord, I order dated 16/8/2023, my lord.
Yes.
Filed by this honorable court, that the petition was directed to deposit 30 lakhs, my lord, against the recovery certificate amount, my lord. But that amount they have not deposited till now, my lord. In the meantime, actually, we have also directed to file our affidavit, my lord. But only just now I have received the instruction, my lord. So I 1 week's time may be given for filing our affidavit, my lord.
Lordship, thing is that lordship, initial as per first order, lordship, we have deposited 50 lakhs. Now, lordship, this company is very strict, lordship, because lordship, the next month, lordship, we have to pay around lordship 1.50 lakhs, lordship, as lordship, puja bonus. So this company is lordship, loss-making company, lordship, for the time, therefore, lordship, we have filed additional affidavit, seeking some time, lordship, so that we could not lordship comply with this order, last order, lordship. So, one thing also is here, lordship, earlier, lordship, there is some provision by this lordship, Commissioner PCCF, they have lordship allowed this petitioner's company to lordship pay the area amount on installment basis.
No.
And if this installment basis is allowed, lordship, it will be convenient for this petitioner, lordship, to pay the lordship entire area amount.
No, but there is an order of the court.
Lordship, that lordship, I agree.
You have to either comply with it or go and
Lordship,
appeal
yes, lordship, therefore, lordship,
or file a review petition.
lordship,
There are only 3 ways out.
lordship, yes, lordship, that's true, lordship.
Which will you choose?
Lordship, for the timing, lordship, they accommodate some time so that we can comply with the order. Minimum 2 months, lordship, so that we can comply with the order.
The entire,
Because next month, lordship, we have to pay lordship 1.25 lakhs to the lordship as a bonus, lordship, puja bonus. So if lordship accommodate 2 months,
Your clients are in contempt of the court's order.
lordship,
Remember.
that is why lordship, we have filed additional affidavit, lordship, seeking lordship.
I will just mark your presence. Otherwise, this is a case where contempt proceedings should be
That's
initiated.
lordship, I agree with you, lordship.
And
There was the
on
order.
his request, we'll adjourn it for 2 weeks.
my-
To
but
file
that
affidavit.
1 week, my lord, will be sufficient, my lord. That just now I have received the instruction, my lord. We'll be able to
Heard
file our.
Mr. J. Kalita, learned counsel for the writ petitioner. Also heard Mr. L.C. Das, learned senior counsel, assisted by Mr. M. Devi, learned counsel appearing for the respondent number 2, 3, and 4, who submits that he has just now received instructions and therefore be granted 10 days time to file affidavit. First of Mr. Das has however pointed out that the petitioner has not yet complied with the order dated 16/8/2023.
Right.
And therefore contempt proceeding is required to be initiated against the petitioner. First of, the said aspect will be considered on the next day after the affidavit is filed by the respondent numbers 2, 3, and 4. This matter stands adjourned for 2 weeks so as to enable the respondents to file affidavit.
Lordship,
Public
before
lordship.
it, I shall try lordship, to convince my client to lordship, at least to comply with this order. 4 weeks, lordship.
You do whatever, don't be emotional and
No,
personal.
no, I'm not emotional, lordship. For the see, the order is there, lordship. Definitely, it is my
There
duty
is
to
order
instruct
of
my
the court,
client.
will go by the law.
Lordship, that's true,
The
lordship.
courts know only one business, that is
Yes.
the law, business of law.
Because of
Of course, we try to humanize our order when
Well-
possible. But otherwise, we have to only dispense justice in accordance with law.
4
Nothing
weeks,
else.
lordship, I'm humbly praying, 4 weeks, lordship. 3 weeks, lordship, at least.
10 days to file affidavit.
10 days, lordship.
Published to lodge.
In the meantime, lordship, I will file reply. If the file, I will. do it. Obliged.
Supplementary list for order, item 16.
May I please your lordship?
Yes.
My lord, here in this case, the present petitioners are the compensate members, my lord, and then brought requisition against the respondent number 8 president on 29/5/2023. Ultimately, my lord, our matter was placed before the respondent number to DC. my lord.
Just a minute, just a minute.
Sorry.
Yes.
Yes, my lord, in this affidavit file, my lord, also in the implement notice reflected, we have been asked to brought fresh requisition, my lord. So my humble submission this, my lord, only on limited prayer, my lord. Your lordship may please to give direction to the DC or my lord, the secretary of the government said within 10 days to hold a meeting, my lord. That is our only prayer, my lord.
That is the only thing you want, and that is
Yes.
everything you can get.
Yes.
You can't get anything more than that.
Yes, my lord, absolutely.
That is the final relief,
Yes.
absolute relief.
Yes, my
So
lord.
don't make it look that I'm giving up everything, I just want this much.
No, my
It's
lord.
not like that.
Yes.
That is everything. So you have to argue your case.
My lord, page 16, the
Who is
requisition.
appearing? The deputy commissioner has filed an affidavit.
Lord.
What is the date of the affidavit?
Of 1st September it was filed. I think my lord, it is 13/9.
13/9.
13/9.
Why is it written additional affidavit? Is it an additional affidavit?
Lordship, it is written, my lord, my lord, that additional affidavit.
Is it an additional affidavit?
My lord, it should not be the additional affidavit. Lordship, my lord, no affidavit has been filed prior to that affidavit, lordship. It should be there as an my lord, the affidavit in opposition. Why it is written, my lord?
So let us see, when was the first requisition issued?
My lord, page 16, annexure 1, my lord. That is on 29 May 2023.
29?
May 5, 2023.
Yes. Then
Then, my lord, on 31st May 2023, there is a note of the president, my lord. It was placed before the president of the Gaon Panchayat, my lord, page 18 annexure 2, 31st May 2023. Thereafter, secretary waited 15 days. Then he placed the matter before the Anchalik Panchayat on 16/6/2023. 6/2023.
Page
Page 20, my lord. And here also, my lord, no meeting was, Anchalik Panchayat failed to hold meeting, my lord. Accordingly, petitioner forwarded the letter before the DC, my lord, at page 21 annexure 4, that is on 26/6/2023.
page 24.
Yes, page 21. The type copy, my lord, the original is at page 23.
All right, so up to sending it to the president of Anchalik Panchayat, there is no problem. What is the timeline? Let us see. Anchalik. Some Panchayat Act. Your junior has not given a list of books.
Sorry.
Some time back, these petitions would have been thrown out only on that ground. Why are you so callous?
I'm sorry.
I'm sorry is this easiest way out, no? Section 15.
Section 15(1).
So 16/6/2023, it was sent to AP president and he had 7 days to take action in the matter.
Yes.
Yes, so where is the violation of the timeline? Where it has been violated?
Violated, my lord, that as part of the provision, my lord, they have to, my lord.
Where, how it has been not followed yet? Which part has been violated? Please point out.
Sorry.
All right, I'm allowing the petition with the direction to convene the meeting within 10 days.
Lord.
By giving 7 days clear notice to the
All the parts.
heard Mr. P.K. Decker, learned counsel appearing for the read petitioner. Also heard Mr. J. Hendick, learned
Lordship, I appear on behalf of respondent number 2 and 3, Lordship.
additional senior government advocate Assam appearing for the respondent numbers 2 and 3. Mr. S. P. Handy, learned SC, Panchayat and Rural Development Department, Assam, has appeared for respondent numbers 1, 4, 5, and 6. What about the others? 1, 4, 5, 6, and 7. Who is respondent number 8?
That's the president of the Gram Panchayat. Private party.
None has appeared for the respondent number 8. The facts of this case in a nutshell are that as many as 4 members. How many members?
My lord, 1, 2, 3, 4, 5 members. My lord, total 7, Lord, two was removed, my lord.
5 members of the Manikpur Niskar Gao Panchayat in the district of Hailakandi had submitted a requisition dated 29/5/2023. Seven members, not 5, 7 members. Submitted. You can't even tell the facts correctly from your own petition. Huh?
My lord.
This is the pathetic condition in
My
which we are
lord,
operating.
Two subsequently were removed, my lord. We have filed additional affidavit.
But they filed
7, all initially 7, then later 5.
before the secretary of the Gao Panchayat with a request to convene a special meeting so as to move a no confidence motion against the respondent number 8, who was the president of the Gao Panchayat. Full stop. Upon receipt of the requisition, the respondent number 7, that is the secretary of the Gao Panchayat, had placed the same before the upon receipt of the requisition on 29/5/2023. The respondent number 7, that is the secretary of the Gao Panchayat, had placed the same before the respondent number 8 on 31/5/2023, seeking his approval to convene the meeting. However, on that date, no approval was granted by the respondent number 8. Therefore, after waiting for a period of 15 days, the respondent number 7 had forwarded the requisition to the president of the concerned Anchalik Panchayat on 16/6/2023, which was received by him on the same date. However, no action was taken on the said requisition for a period of 7 days as permissible under the law. Full stop. Situated thus on 26/6/2023, the respondent number 7 had forwarded the requisition to the respondent number 2, that is the Deputy Commissioner, bracket now District Commissioner, bracket close, Hailakandi, for doing the needful. When no action was taken by the respondent number 2 for convening the special meeting, the instant writ petition has been filed, inter alia praying for a writ of mandamus directing the respondents to convene the meeting. The respondent number 2 has filed affidavit wherein it has been stated in paragraph 2 that the special meeting could not be convened to discuss the no confidence motion since the respondent number 7, that is the secretary of the Gao Panchayat, had committed a mistake in his failure to adhere to the timeline as provided under the law. As
My lord,
such,
as far the assertions that are made by the DC are concerned in his affidavit, there has been a calculation mistake that has been done. He has not taken into consideration
Yes.
Section 9 of the General Clauses Act. He has added a day extra on
Right, right.
every occasion.
As such, the requisitionists were advised to submit a fresh requisition for convening such a meeting. Full stop. In the affidavit, it has further been mentioned that the secretary of the GP has admitted his mistake in the reply of the show cause notice dated 30/6/2023 served upon him. Accordingly, warning was issued to the respondent number 7 not to repeat such mistake. Full stop. Mr. Deka has argued that there was a mistake in the calculation of the time lines as provided under section 15(1) of the Assam Panchayat Act 1994 made by the respondent number 2, as a result of which the meeting was not convened by him. Full stop. It is to be noted herein that as per section 15(1), where is the General Clauses Act? Show me the.
Well, section 9, I do not have a copy, I have a soft copy. Section 9 of the General Clauses Act 1877 and Paramateria Assam General Clauses Act, same section, my lord, commencement and termination of time, section 9.
As per section 15(1) of the Assam Panchayat Act 1994. When a requisition expressing want of confidence on the president or vice president of the Gaon Panchayat is received, the meeting is required to be convened by the secretary of the Gaon Panchayat with the approval of the president. Or the vice president, as the case may be. Now, vice president, depending on the person against whom the motion is proposed, comma, within a period of 15 days from the date of receipt of the notice. First up. If, however, no such meeting is taken within 15 days, then the secretary of the Gaon Panchayat shall, comma, within 3 days thereafter, comma, refer the matter to the president of the concerned Anchalik Panchayat, who shall convene the meeting within 7 days from the date of receipt of the information from the secretary of the Gaon Panchayat and preside over the same. Full stop. In case the president of Anchalik Panchayat does not take action in the matter within the specified 7 days time, then the secretary of the Gaon Panchayat is required to inform the matter to the deputy commissioner stroke subdivisional officer bracket civil bracket close as the case may be, comma, within 3 days after the expiry of stipulated 7 days time, whereafter the concerned deputy commissioner stroke subdivisional officer bracket C is required to convene the meeting within 7 days from the date of receipt of the information with intimation to the Zilla Parishad and the Anchalik Panchayat and preside over the meeting so convened. Full stop. In the present case, the time available for the president of the Anchalik Panchayat to convene the meeting was for a period of 7 days with effect from 16/6/2023.
Which ended on 23/6/2023. madam.
Ended on 23/6/2023. Full stop. Therefore, 3 days thereafter would end on
26/6/2023. And the letter was sent to the DC on the same day, on the last day, that is 26/6/2023.
It is not in dispute that the letter by the secretary of the Gaon Panchayat was sent to the respondent number 2 on 26/6/2023. If that be so, it cannot be said that the letter was received by the respondent number 2 after the expiry of the statutory period as per prescription of section 15(1) of the Assam Panchayat Act. Mr. Hendik Lanet, Standing Council PNRD Assam, has submitted in his usual fairness that as per the provisions of section 9 of the General Clauses Act 18, what is the
Section 9 of the General Clauses Act
General Clauses.
1877, my lord.
1897,
1897, sorry.
which has a perimeter provision as in
Section 9 of the Assam General Clauses Act 1912.
Assam General Clauses Act 1912. I want this.
12.
Dealing with commencement and termination of time.
So here the DC has calculated the first day, my lord.
23/6/2023 ought to have been excluded. from
Ought to have
the-
been included. The last day has to be included, my lord. Say, for example, from first onwards. So we will start counting from the second, third, fourth onwards. So he has
That's
calculated.
right, 24, 25, 26.
Yes, sir.
23/6/2023 ought to have been excluded
Yes.
while calculating the 3 days time, which would evidently expire on 26/6/2023. Therefore, it is a clear case of a mistake committed by the respondent number 2 while computing the timeline prescribed under section 15(1) of the Act of 1994. Mr. J. Hendrik Lanet, additional senior government advocate Assam, has also supported the said contention of the departmental council. After a careful reading of the provision of section 15(1) of the Act of 1994, in the light of the materials available on record, this court is also of the opinion that the last date for the secretary of the Gaon Panchayat to communicate the requisition dated 29/5/2023 to the respondent number 2 was 26/6/2023. Full stop. Since the respondent number 2 had in fact received the information from the respondent number 7 on 26/6/2023. It was not a case where the respondent number 7 had exceeded the timeline as prescribed by section 15(1) of the Act of 1994 while furnishing the information to the authorities as delineated under the said provision, including the respondent number 2. Situated thus, this court is of the unhesitant opinion that the view taken by the respondent number 2 in this case was clearly erroneous. As such, this writ petition succeeds and is hereby allowed. The respondent number 2 is now directed to convene a meeting of to convene a special meeting of the Gaon Panchayat so as to discuss the no confidence motion proposed against the respondent number 8 and preside over this meeting. The meeting will be convened within 10 days from the date of receipt of a certified copy of these orders by giving 7 clear days notice to the members by intimating the place and time of the meeting, date, place and time of the meeting. With the above observation, the writ petition stands disposed of.
For hearing item 7.
That's an application, my lord, for quashing of a police case, my lord, in Mumbai, my lord. My lord, the facts of the case is this, my lord. The respondent number 2, my lord, they got some order from Power Grid Corporation for supply of PSC poles, and the petitioner is a manufacturer of PSC poles. They placed some order. Then, my lord, they paid some advance. During inspection, my lord, some poles were damaged. Subsequently, my lord, the order was cancelled, and some amount were lying, my lord, with the petitioner. They asked, the petitioner, my lord, asked for settlement of the account several times. If you'll also see, my lord, page 64 onwards, we have issued my lord letter that they should ask they should come for settlement to account, my lord. Account.
Who is appearing for the respondents?
Respondent, my lord, respondent to Kalyan Bhattacharya was appearing. Junior, my lord, his junior, my lord, prayed for some time. My lord, here what happened after that? They asked for that amount. We, as per our account, my lord, we have settled the account. Out of 18 lakhs and all, 10 lakhs we have sent them. My lord, the account is settled, my lord. We are lordship will find, my lord. Page 65, they asked for this amount. 18 lakhs and all, out of which page
So,
66.
Mr. Sahiwala, has the state of Maharashtra been served in this case?
Well, yes, they filed an affidavit, but nobody is appearing, I don't know.
Who is appearing?
Nobody is appearing, I don't know.
Affidavit must have been filed by someone.
Yes. My lord, one affidavit has been filed, my lord, on behalf of the police service structure. This is a civil dispute, my lord. They issued several notices for arbitration, my lord, and also under Companies Act. Well, I shall place those.
Where is the FIR?
My lord, FIR is at page, my lord, 86. For 15, 4, 17, 18, 20, 420, and 20, my lord. This is not a question of my lord.
It on heard Mr. G.N. Sahiwala, learned senior counsel listed by Ms. A. Bhattacharya. Learned counsel appearing for the writ petitioner. None and writ petitioners. None has appeared for the respondents, although the name of the counsels have been duly shown in the reflected in the cause list. This writ petition has been filed with a prayer to quash CC case number 187/SW/2012, registered under section 415/417/418/420/120B of the IPC at the Wadley Police Station, Mumbai, Maharashtra, on the ground that the respondent number 2 has lodged an FIR on raising a dispute which was purely of civil nature. Full stop. The police case being CC case number 187/SW/2012 was apparently registered on the base of the FIR dated. Is it FIR or complaint?
FIR, my lord. They say complaint, but FIR, my lord.
On the FIR/complaint dated, what is the date of the complaint?
My lord. It is even, my lord, yes.
Date is not there, no? No date is there.
December 12th, my lord.
Undated complaint stroke FIR lodged by the petitioners in the month of December 2012. Taking note of the grounds taken in the writ petition that the FIR does not disclose the ingredients of any cognizable offense, I have gone through the same and find that the dispute between the petitioners and the respondent number 2 was pertaining to demand for refund of a amount of rupees 18 lakhs 08, seven.
Not 18 lakhs, my lord. Now with that 10 lakhs has been paid. So now.
Original was 18 lakhs.
Totally.
Yes, 18 lakhs, 8,732.
Yes.
Which according to the complainant, stroke respond number 2, the petitioners had failed to refund even after cancellation of the purchase order for supply of PSC poles.
Yes.
Full stop. Mr. Sahiwala submits that during the pendency of this writ petition, the dispute between the parties have been settled by paying a sum of rupees 10 lakhs to the respond number 2. Full stop.
10 lakh and odd, my lord.
Huh?
10 lakh and odd.
10
10 lakh
lakh bracket
23,000.
approx to the respond number 2. Full stop. The respondents' counsel are not present to deny and dispute the said assertion.
Arbitration notices has been issued, my lord.
Huh?
Arbitration notice has been issued several times.
Uh,
They issued the arbitration notice.
Be that as it may, Mr. Sahiwala has further submitted that to adjudicate the remainder of dispute between the parties, arbitration proceeding has already, arbitration notice, who is,
My lord, the advocate of the respond number 2, my lord, issued several notices for arbitration.
notices for initiation of arbitration proceeding has also been issued by the counsel for the respond number 2, and therefore there can be no element of doubt in this case that the dispute raised in the ejahat, in the complaint stroke FIR is nothing but a purely civil dispute. Full stop. After going through the materials available on record and on hearing the submission of Mr. Sahiwala, this court is also of the unhesitant opinion that there is no ingredient of a criminal offense, no ingredient of an offense punishable under section so and so of the IPC. Rather, the dispute sought to be raised in the complaint by the filed by the respondent number 2 is purely of a civil nature, in respect of which civil proceedings have allegedly already been initiated. In view of the above, this writ petition succeeds and is hereby allowed. The FIR dated, so the complaint dated, now the police case in the form of CC so and so is hereby set aside, quashed and set aside. It is however made clear that it will be open for the parties to, it will be open for the respondent number 2 to avail all other legal remedies as may be permissible under the law, so as to enforce any debt against the petitioners hearing as per the provisions of law.
My lord, I am fully responding. Lord, just now, Mr. Ram Sekhi and learned advocate for the petitioner told me that he is going to draw this petition becoming.
He is going to
withdraw the petition. He is coming in the way.
let him come.
Item 9.
Well, in this case, the petitioners who are the employees association of the respondent corporation, particularly Assam Textbook Corporation, took up the cudgel, my lord, initially. They had challenged the requisition of the land belonging to that corporation, my lord. It's a government corporation. Challenging the requisition on the ground that, my lord, they had their own need, my lord. They needed to construct a godown for their books. And at that point of time, they were renting place elsewhere. But notwithstanding that, my lord, the land was requisitioned in the year 2007 and in the year 2009. My lord, an agreement was executed between GMDA and the corporation, my lord, for construction of an automated parking system, my lord, at Panbajar. It's just by the side of the flyover, my lord. There was an agreement to share the profits on 50-50 proportions. But nothing happened, my lord. The institution was sought to be given the contract, my lord. Simplex, they had left, saying that it was not possible to construct that there because of the statutory rules. And thereafter, my lord, the thus corporation suffered, my lord. That land also they couldn't use. And it remained like that, my lord. And all these years, this is year 23. Now there is an order, my lord, passed on by this court after hearing all the parties, my lord, on date 14/5/2019, my lord.
14/5/2019. Yes.
And pursuant to this, my lord, they filed an affidavit, my lord. They saying that they are now, they would like to convert into open parking, my lord. Just a parking space, my lord. And instead of the original 450 vehicles and 200 odd two-wheelers, now the land, my lord, according to can park only 121 vehicles, my lord. It has come, but it is not a part of the agreement. This was not the agreement, my lord. And they have not rescinded the agreement, nor they have de-requisitioned the land. And in that, my lord, now the corporation has filed an affidavit, my lord. I think this will be relevant, but this is the stand they are supporting it. On principle, they are supporting the employees now.
Who's for the corporation?
Supporting, we are Procurement Respondent is supporting it because we are losing it. This land was taken away by GMDA, they didn't utilize it. And my lord, till now, my lord, neither they are coming up with any projects. Neither giving us any degree.
So we'll close it by providing that whatever use this land is put into, the same will be done on the basis of an agreement reached between the corporation and the petitioners, along with the GMD authorities. That's
Place agreement or with consent of the corporation. The consent has to be taken into confidence, my lord. That because the initial that thing was that couldn't be executed as agreed to, my lord.
So I take down heard Mr. B.D. Goswami, learned counsel appearing for the petitioners hearing. Also heard Ms. M. Bordello, learned standing counsel revenue department, appearing for the respondent number 1. And Mr. D. Gogoi, learned counsel appearing for the Assam Textbook Production and Publication Corporation. That is the respondent number 6 hearing. Mr. J. Hendik, learned additional senior government advocate Assam, has appeared on behalf of the respondent numbers 2, 4, and 5. None has appeared on behalf of the remaining respondents. The writ petitioner number 1 hearing is a union of the Assam State Textbook Corporation employees and is represented by its General Secretary, who is the respondent number 2 herein. First up. Agreed by the agreement dated 19/9/2009, entered into by and in between the respondent number 3, that is the Guwahati Metropolitan Development Authority, bracket GMDA, and the respondent number 6, that is the Assam State Textbook Production
and also, my lord,
and
the
Publication Corporation.
But the requisition or order also which alliance, that is at Annexure 1, dated 26/10/07.
As well as the order
Page 21.
requisitioning, as well as the order dated
My lord, 26/10/07.
26/10/2007, requisitioning an area of land measuring 40.14
R
and
village Sohar Guwahati Part 4.
situated at village Sahar Guwahati Part 4 under Moja Ulubari under Moja Ulubari, comprising of Dag number 440 of Patta number 269.
My lord.
The Employees Association have approached this court inter alia contending that the plot of land belonging to the respondent number 6 is required for the purposes of building the infrastructure.
Go down, my lord. Textbook
Namely,
go down.
go down
Yes,
for storing of textbooks
yes. my lord.
for the corporation itself, and therefore there was no justifiable ground for the authorities to requisition the aforesaid plot of land for construction of a parking area, is
Yes,
it?
ma'am.
A parking area, first off. Due to an interim order operating in this case, there is an interim order, is it?
Not as such, my lord.
Due to the
It is
pendency of
mentioned
this
in that,
proceeding-
my lord, but there is no such interim order. No
It
stay.
appears that due to the pendency of this proceeding, no further action was taken in the matter.
Yes.
And at present, the agreement dated 2009 has also spent its force, meaning thereby that the aforesaid project is unlikely to materialize at this point of time. Full stop. Under the circumstances,
Yeah, as per their own stand, my lord, GMD stand, my lord. They
As
have
per
filed
the
affidavits.
stand taken by the GMD
Yes.
authorities in their affidavit. Under the circumstances, the petitioners have argued that the
Land be
respondent-
de-requisitioned and returned to the
land in question be de-requisitioned and returned to the
corporation.
corporation for being utilized for the purpose of the corporation itself.
Yes.
First step. Mr. D. Gogoi, learned counsel for the respondent number 6 submits that he has instructions to support the case of the writ petitioner's hearing. Full stop. And the learned government advocate Assam as well as the standing council revenue department Assam have also not opposed the prayer made by the petitioner's counsel. Full stop. The counsel for the GMDA is not present before the. No. Yes, yes. What is your submission? You are sitting there. The learned counsel for the GMDA, namely Ms. S. Sutia, submits that she has no instructions in the matter. What are you trying to say? Are you present or are you absent? What is your instruction? The counsel for the GMDA, namely, whose name should I record here? Huh? Mr. P. Nayak submits that he does not have any updated instruction in the matter. First up. If the original agreement dated 19/9/2009 has become unenforceable, then it is apparent that the writ petition has become infructuous in a way. However, since the land in question has not yet been de-requisitioned, and in view of the stand taken by the learned counsel for the GMDA, a direction would be required to be issued by this court to de-requisition the land. Accordingly, this writ petition stands closed by providing that the land in question shall be de-requisitioned by the authorities by following the due process of law. First of, for future purposes, if the land is required to be put in use for any public purpose, the same shall be done only after due consultation with the respondent number 6.
Yes.
With the above observation, writ petition stands disposed of. Yes, next matter.
Obliged, Judge.
My lord, Mr. Secretary.
Yes, you want to withdraw the case?
I'm sorry.
You want to withdraw the writ petition?
That's, I will make the information, get the information to tonight. Because one day they told me that this should be withdrawn, but I told them that give me in writing. Because there are a good number of members of the society. So 1 week time may be granted, only 1 week.
Mr. R.C. Saikal, I'm a counsel for the petitioner, submits that as per oral instruction received by him from the petitioners, there is a decision to withdraw the writ petition. However, awaiting written instructions from his client, this matter be adjourned for a week. Mr. S.P. Roy, learned counsel appearing for the respond numbers.
4.
Respond number 4 is as well as Mr. J. Hendik, learned additional senior government advocate Assam are present and do not have any objection if the prayer is allowed.
Fine,
In view of the above, registry will list this matter again after 10 days.
fine, oblige.
Item 11.
Yes.
The matter relates to the making of the BIS mark.
Making?
BIS mark,
Lordship, I'm appearing behalf of K. Google, Lordship, for CGC. Can the matter be fixed at 2, Lordship? He's on another code, Lordship.
No, this is the last matter, is it? No, that won't be possible. This is the last matter of the day.
Yes, Lordship.
Not possible. Yes.
In respect of phenyl and melamine, which is imported from outside. Now, the direction is from the central government for making it the BIS mark compulsory. I will take you, Lordship, to first the general agreement of tariff and trade, which you Lordship find at page 182.
Dr. Saraf, how much time will you be requiring?
At least 2 days.
At least
2 days.
2 days. What is the issue here really?
Well, the issue, in fact, I will tell you that the BIS mark that had been at the instance of some domestic producers. Now, under the Act, the BIS mark can be made, direction can be issued only when there is some about the interest to consumers, health, second, the national security, third, unfair trade practice. These are the regions, Now, the regions which have been, the representations which have been submitted by the domestic industry, is that their production is sufficient to meet the requirement. And because of the import of all this phenyl and melamine from outside, those industries are affected and they are suffering a loss. I'll take a Lordship to the representations and considerations. Now,
so is there any interim order in this case?
The interim order is only to the effect that in case they take a final decision in the matter, that should take a leave of the court. Nothing else.
They means who?
Government of India. Before taking a final decision in the matter, they should take a leave of the court. And no such leave has been sought for.
Because you will take 2 days to argue this case? How much?
Unless
appearing for whom?
I am appearing for respond number 7. In my view, there are certain preliminary objections as far as the maintainability of this petition is concerned, and there is a direct
So
judgment.
this matter is for final hearing, no question of maintenance.
Yes, very well, but maintainability which goes to the root, jurisdictional issues.
No, Mr. Sharma, you see, what I am trying to figure out is.
Yes, what is the
there is
core
no
issue?
question or now it is not possible to give 2 days for this matter.
Of course, it will not take, when my learned friend mentioned about 2 days, on a more of an anecdotal issue, what I'm remembered of, we had, right in my initial years, we had briefed Mr. Shanti Bhushan for a matter. And he was a legend, and the matter didn't have anything. And on the technical side of it, the matter was very weak. So as a junior, he told me, and I didn't understand, he made us take 3 bags of books And he made sure, my lord, we kept all those books on the side so that the judges could see, my lords. So, and he told us, as your lordships would know, my lords, that if you don't have anything, my lords, scale up the matter so much, my lords, that matter gets scuttled. My lord, the core issue,
I've strongly observed. So what you want to say?
the core
What
issue
you
here,
want
my
to
lords,
say?
the core issue, yes,
No, no, no,
that's
you
exactly
want
what
to-
I'm saying, my
not
lords.
fair. That there is no case we are trying to show the books and like Santi Bhushan. Yeah, unexpected. This is not proper. This is not such type of statement shouldn't be made.
Well, it's the core issue here, my lords.
He the interviewer, again, I am raising the objection. Core issue, why he will say?
No, just a minute, Dr. Saraf. Mr. Sharma, I
Yes.
don't think that example or anecdote
Yes,
was.
very well.
You see, what I am saying is, what is your urgency? This judgment cannot be delivered before vacation. Forget it.
Correct, my lord.
So then the question is, why
But
should we hear this matter before vacation?
Only thing is, my lords, today what is happening as a result of that particular order, my lords, the certification of phenol
File an IA will clarify that they can go ahead.
and
This pendency of this.
very well,
repetition.
my lord, very
File
well,
an IA.
very well. I have no
Because you
difficulty.
see, we have heard matters.
Yes, my lords.
And whatever, I mean, as a senior counsel, he is entitled to place his case.
Yes, absolutely. I have
You
no
may
difficulty.
also have, see, we are approaching the vacations very soon. And on a day-to-day basis, this matter does not call for that kind of attention and it will not be possible. So if we start a hearing, you will put it as again in the rolling pattern and it goes beyond the vacation. So you are an intervener, you may have a interest affected. To that extent, the court has no difficulty. But you can't compel the court to hear and decide.
No,
the
I'm
matter
not.
at a-
I can
So
never
if
do
you-
that, nor am I,
If
my
you
lords.
want any clarification, why don't you file an IA? We'll issue the.
Your
clarification.
lordships
We
will
can take it up
clarify.
tomorrow.
Lordships will clarify only, my lords, and lordships will hear it at your lordships' leisure and convenience. Lordships will clarify that the interim order will not stand in the way, my lords, of the government passing any order on merits, my lords. And
But
this,
then they will have to take the leave of the.
yes, my lord, final order, as and when they take the final order, my lords. What
No, we'll
the
say that
impression
interim
seems
order-
to have been created.
Interim order will not come in the way for the government
Yeah.
to consider the matter on its own merit and take a decision.
Yes, my lord, lordships will clarify
The
that.
lordship has only.
But before notifying such a decision, the matter
Your
will
lordship has
place-
only passed the order before taking a final decision, take the leave of the court. Your lordship has not restricted them to consider and proceed. Your lordship has not restricted. Before taking a final decision in the matter, take a leave of the court. Now that has to come from the central government. You know,
No, that is correct. You see, his client may also have, will have a genuine issue here.
The client may have, but the decision has been taken by the central government. He is the interested party. Now the central government has
What
to
is
come-
wrong in being an interested party?
No,
He
I
can
will
be-
tell you, I will place, if you also wants to hear that one, that whether the interested party can come up for modification of the order. Well, in the division bench also, the interested intervener wanted to file an appeal, and that has been dismissed. The no leave was granted by the division bench, that no, the leave cannot be granted to file a late appeal. Your lordship is just.
No, see, just a minute, Dr. Saraf. You see, we are on a slightly different area. You say the matter will take time for you. to
Certainly.
take it up. Maybe it will. At the same time, he has some urgency. His client would like to see this matter end this way, that way, at the earliest, correct? So if we balance both the sides, then the reason for his urgency is that according to him, due to pendency of this writ petition, the matter has been put to cold storage. Is that what you are
I'm
saying?
so grateful. I'm so grateful.
So, which is not the intention of the court. Even in passing the interim order, the intention of the court was not to stall the process.
We have never
The
said.
only intention was that.
Final
before-
decision should be
yes,
taken.
So that the cause of action in this writ petition is not finally obliterated. So there could be nature of decisions which in any case will not obliterate the clause of action. And there could be decisions which will be only apparent if a decision is taken. But if he's seeking that clarification that this interim order will not be construed as a direction to stall all process of consideration of the matter on merits, then his client will also be happy for.
I'm
that.
so grateful for that. That is exactly what the difficulty was, Mala. Their lordship has understood in 2 minutes.
Because you see, when we hear a matter, we have to deliver the judgment and
I have,
we are approaching the long
I
vacation.
understand.
Will Mr.
I
Sharma, you will
completely
allow me?
understand. Have
Or
I,
as an intervener, you will argue?
well, have I argued, Malad? I
No,
don't
you are saying-
understand this.
you have said that
This-
you are lost-
you will
Somebody,
speak-
just a minute, somebody wanted to be on VC in this matter?
Malad, I came down.
Acha, you
I
wanted.
had
Well,
requested initially,
when
but
the lordship is saying something in favor of the intervener, then your lordship was understood in two lines.
Acha, which is
And
the
when I
order?
am saying, then Santi Bhushan comes. Then Santi Bhushan comes that 2 days, the bogus things. Well, I will just only say, my lord.
Which is the interim order, please?
No, I just a minute, my lord, lordship may kindly hear me. Lordship may kindly hear me, no?
Observation to that effect, my lord.
I have strong objections to the intervener praying for a modification of the order. If your lordship, at the instance of the intervener, wants to modify the order, then your lordship may hear on that issue, pass the order,
No, not modifying,
clarify.
clarify.
My submission that your lordship, at the intervener has no right. Intervener has no right whatsoever for any clarification or for modification or anything in the order. In case your lordship is satisfied that at the instance of the intervener, your lordship wants to clarify and so, then I may argue your lordship may pass the order thereafter
You will argue for 1 day.
on that issue.
Yes, for a day.
Not that your lordship he wants to say that 10 minutes I can, as your lordship has understood in 2 lines with 5 minutes submission of Mr. Sharma. If the way, same way in 2 minutes, your lordship can understand my views, I will argue for 2 minutes only. But if your lordship is not convinced of my argument, I will argue.
All right. Which is the order?
22-1-2021. There's already an interim order.
22-1.
By TK records. I think that my lord, final call can be taken only after leave of the board. The ministry basically has to take a decision as of now in consultation with BIS. I am representing the BIS.
22-1-2020. Yes. Yes, Dr. Sarat.
So, my lord, I make my submissions on the.
Now, please clarify one thing. When respondent number 7 was impleaded, by the way, you were not heard in the matter? Was it done without hearing the petitioner or?
No, it was heard. He was not made a party respondent. He was only one to pleaded as an intervener. No, there is a difference between the party respondent and an intervener. And the apex court has made it very clear that intervener's role is very limited. Intervener has no separate cause of action. And if the intervener has no separate cause of action, then the apex court has said that someone may have a commercial interest. It cannot be made as a party.
Is intervener is a defined expression?
Intervener is there, the judgments.
Yes, what is the meaning of intervener?
Intervener is that in proceedings are there where he may intervene. Something is there. He may be, because certain cases he may be commercially affected. He may be interested in that one. But the court has said that apex court said that will not make him a party respondent. The person who is commercially affected and all those things, that will not make him a party respondent. Now, he was not allowed as a party respondent. He was only allowed as an intervener. Now, against that, he has not gone in appeal. That order becomes final as an intervener. He is not a party respondent. Now, intervener's role is either to support either of the parties. He can support the petitioner, he can support the respondent. In this case, apparently he's supporting the respondent. But the intervener at his own, in my humble submission and about in view of the judgments of the apex court below, you'll also see the judgment below. So, that is, my lord, 1999 3 SCC 141 Supreme Court. Last paragraph, paragraph 12.
Yes.
The only purpose of granting an intervention application is to entitle the intervener to address arguments in support of one or the other side.
Second paragraph.
Itu ডাঙৰ আছিল intervener কেতিয়া হয় কেতিয়া নহয় itu দিছা
So it is basically the respondents 1 to 6 who are represented by the CGC. Is it? Who is appearing for the?
But central government or the BIS, my lord. Central government or the BIS. Bureau of Industry. You'll also see, my lord. Paragraph 12, my lord. It has Supreme Court rules. It is obvious that this LPA is filed by the intervener. It cannot be disputed that intervener in the petition has only the right to address the court for the respondent one. The appellant cannot refer this appeal, and he has in fact no locus to challenge the impugned judgment and order. It is difficult to disagree with the learned counsel. It would be seen that the petition from which the impugned order arises was the petition between the respondent one and the other respondents. The intervener applicant has addressed the court. The grievance of the respondent one was mainly against the respondent 2 and 3 for the election of the respondent 4. His grievance was regarding non-acceptance of his nomination form. Therefore, the intervener cannot be said to be directly connected or the aggrieved party because of the impugned order. Learned counsel for the appellant did not rely on any authorities to make out a case that even intervener can file an appeal when the submissions have been heard and considered while deciding the relevant petition merely because he claims to be aggrieved. The same will not be sufficient to mend the present appeal. In our considered view, in a case where the intervener is not directly affected by the order of the court, and when he is not a party to the proceeding, he cannot be held to be entitled to file substantive appeal to challenge the judgment and so on. So. Intervention to
So at this stage, except for filing this writ petition on an apprehension and the pendency of the writ petition, there is no order operating, there is nothing as such operating.
Well, only recommendation has been made by the expert committee to include the melamine and phenyl in the BS marking. This honorable court, after considering, has not barred the respondents to examine and proceed in the matter. The only thing that you, if you pass a final order before that, you take a leave of the court. Now, if the central government had decided, finally, they will come up with the leave of the court for seeking the leave of the court. But they must, the central government must come and say before a lawsuit that yes, we have decided and we want to pass your order, we will seek leave of the court. Before that, without that, my lord, if my lord, you are asking, just consider, my lord, an interested party who filed an application for BS marking before the authorities, and the challenge by the petitioner is the decision of the, or the contemplated decision of the central government. Now, is the interested party who was there, who was commercially interested or by someone interested, he's interested that the central government must be allowed to do this, now allowed to do this. We were also there before the central government, when meeting was there, he was also there. Now, central government is an independent person who will examine all those three issues. If at this stage, the intervener who is interested party is allowed to get the order modified by the petitioner, which was petitioner was, according to me, there is no interim order as such. There is no restraint order that you cannot proceed, you cannot examine it. That will amount to the intervener dictating, entering the shoes of the central government. Central government is not coming up before your lordship saying that yes, we have taken the final decision or we are going to take a final decision, kindly grant us leave. How the intervener can say that the central government is not in a position to do this? The submissions made by the intervener clearly shows that, in fact, it's the assistance of the intervener the things are going on. How the intervener can say the central government is not in a position to do this? This has to be submitted by the central government, not by the intervener. In my humble submission, my lord, by many means, my lord, when in a single bench, my lord, the question was decided against the department, where he was also intervener, he filed an application for leave to challenge the order of the single judge. That was dismissed by the division by a speaking order.
So why don't you file your note on written submissions, all parties?
Very good. We do that.
But the problem is before vacation, whether hearing will be, we can post it, but.
No, before vacation, I mean, before 10 days of the vacation, well, always this motion day and everybody is.
I'll leave it to your lordship. I'm
not saying that. I'm not saying that. Look, but fixing a matter only is not sufficient.
No, you see, this matter will have to be heard and finished in one go. There's no point in
absolutely
piecemeal.
If I could just.
And I will not be able to fix it within the next 10 days, this case.
Very well, my lord.
So it is not serving any purpose in any case. Now, let's not swear too much into the intervener and who has what right, what not. This is a 2019 matter. We'll finish it off.
That's why I
finish it off.
After vacation, you'll also fix up.
But
Will hear it finally dispose of.
But
whatever
before
time,
that, even the central government is not there. So we'll fix a date for submission of written arguments.
My lord, I will do that, my lord. But the only aspect here, my lord, is that the whole process, I mean, a learned friend says that I am in cahoots with the government of India, my lord. If that was so.
No, that is his argument.
I know, my lord. But if that were the case, I would not be here, my lords. That the proof is in the pudding. So, my lord, what he challenges, just 1 second, I didn't interrupt him, my lords.
You can put me inside Shanti Bhushan's legs. And I cannot put him in central government. What is there?
Shanti Bhushan was a legend, so I put him in the same category.
Profession, everybody is legend. Don't say all those things.
So, my lord, my submission is this, my lord, that what he is challenged is primarily a recommendation. And my lords, it is in the teeth of a judgment of the division bench of the Gujarat High Court, Justice Pardiwala as he was then, my lord, which clearly says that issues with regard to BIS, on what product, my lord, the BIS stamping has to be there, what product it should not, my lords. These are all technical issues in the domain of expert, my lords. The courts should not get into this particular domain and examine matters. One. Admittedly, my lords, this is a matter of policy. They themselves, when they gave the representation before the government of India, they clearly mentioned that this is an issue of policy decision by the government of India. So the question is, and this was exactly the issue which fell before the division bench, my lords. Division bench says, no, we are not going to be entertaining a petition like this because it is outside our domain. In fact, the country needs a registration, a country needs better products, etc., my lords. So therefore, these registrations are important. But who are we to say whether these products need a registration of BIS or a marking of BIS or not? It is for the expert body. There is an expert body which is created by the legislature, and that body will do the determination and pass orders. So the scope and ambit of this is actually very, very narrow. And my learned friend has absolute right, to argue to his heart's content, there's no difficulty on that. And I'll not pinch him on that, not at all.
How you
But
can,
my contention is, would a matter need so much of judicial time, when it is directly covered by authorities, and the issue is on the jurisdiction of the court, to entertain petitions of this nature,
my lord,
I'll leave it to the
my lord, your
wisdom
lordship,
of the court. As in any case, I'm an intervener, as he says, I can't say more than what my learned friend's affidavit says. My jurisdiction, or scope before this court is limited. I cannot raise one single point, which is not raised in the affidavits of my learned friend. And I'll not raise, anything.
my lord,
If they have raised objections on, and if they said it is a public policy, issue of public policy, I can raise that argument as an interview.
my lord,
And that is what the Supreme
the
Court says.
Gujarat High Court decision, division bench, only because it was delivered by Justice Padiwala, it will not become a Supreme Court decision. It is only persuasive value. So nothing like that, my lord. Again, he says always Justice Padiwala, whoever may deliver as a Gujarat High Court.
Yeah, it's all right.
So, my lord, the question is that this is not a case where one can say that it's covered by Supreme Court judgment. Gujarat High Court decision may be there, maybe have persuasive value, but one cannot say that because Gujarat High Court decision is there, your lordship should close and so take the same view. I will address your lordship on all the issues, and I will take the shortest possible time, whichever is needed. But
Yes.
I have to place my case before your lordship. I place it in
That's-
submission
that's
also.
okay. So, the CGSE is not here, is it? All right, so can we agree to disagree in this manner?
Of course,
That this matter will fix it in about 2 weeks or 3 weeks' time
Very,
for circulating the written arguments
very.
along with notes on written arguments. On that day, you are welcome to come here. If
Yes,
you have any difficulty, be on VC.
I'll come.
We'll fix a firm
Yes,
date.
yes.
On day-to-day hearing, the order will be that it will be taken up for day-to-day.
I'm so grateful.
But that will be sometime in November.
Very well, whatever
Right.
date, any clear
And
date, I'll be happy.
will, if as a judge, you get a scope to come prepared by going through the paper.
I will file it 1 week in advance.
So that cut shorts the time
Yes.
substantially.
You wait for our submission, thereafter you file, that will be better.
Huh?
I am saying that we
No, no.
wait for
He
our
cannot join
submissions.
issues on this particular
No, no,
aspect.
I am saying only-
I'm only assisting the court,
I am
nothing
saying
else.
that After getting our admission, you file so
If
that you can.
necessary, supplementary arguments. will be
Yes,
filed.
yes, I have no objection.
Dr. A.K. Sir have learned senior
Better
counsel.
for both the councils, no?
Huh? NN Datta, learned counsel appearing for the writ petitioner. I've also heard Miss NN learned counsel appearing for the respondent numbers 1 to 6. Who submits that our senior Mr. K. Gogoi, learned CGC, who is appearing in this case on behalf of respondent numbers 1 to 6, is not available. And therefore, this matter be taken up on some other day. First up, Mr. P. Sharma, learned counsel, appearing for the respondent number 7. That is the intervener in this proceeding. On the other hand, submits that the writ petition deserves to be taken up for expeditious disposal due to the implications dependency of the petition would have on several entities, including his client. First of all, after taking note of the submissions made by learned counsel for the parties, this court is also of the opinion that the writ petition should be taken up for expeditious disposal. However, since the learned CGC is absent today, the said process cannot be undertaken. Said process cannot be undertaken today. As such, this writ petition is directed to be posted again on, we'll have it on when? 13th of October? 13th of October for submission of written arguments?
Yes, madam.
13th of October 2023 for necessary orders. On that date, the parties to submit a written note on their submissions along with the decisions and along with the decisions relied upon by each of the parties in support of their contention. Thereafter, a date of hearing will be fixed in this case. First of, if necessary, this matter will be taken up for hearing on day-to-day basis.
Well, let it be on 18th October. my lord.
Huh?
Let it be on 18th October.
18th October, Mr. Sharma?
For written submission only.
Day-to-day hearing. On a date to be fixed by the court on the next posting. Right? Next posting will do it.
Will be for 1, 2, 3 and 5, 6, 4 and.
Acha, then 1, 2, 3 and 5, 6, and Mr. B Pathak for response number 4. You submit your, file your written arguments. Make it
Sure.
short and crisp.
Yes, madam. 3-page is what the norm nowadays
It
seems
will
to
not be
be.
possible for my, for 3 pages. Whatever written submissions are there. So,
What is the meaning of agreeing to disagree?
my lord, agreeing, disagreeing, one thing is there, my lord. The 3 pages, somebody is competent because his case is very strong, and as he said, our case is weak, so we will take whatever written submissions we file.
No, but he will come up with better anecdotes for the next day.
Absolutely.
He can file 3 pages. I am not capable of filing 3 pages.
Malad, just one small request, Malad, since your lordship will have it on a part heard. Because lordship has
No,
heard it.
this bench is not changing.
Oh, very well.
And you also mentioned that for written submissions, so automatically to come. If it comes before the court also will mention it.
I'm so grateful.
What this court would like to do is deliver the judgment expeditiously.
I'm so grateful.
So hearing a matter and keeping it
Yes.
doesn't make any sense. And before puja vacation, you know the situation here.
Yes, madam. I understand.
So therefore,